This is a meeting of the Council of the International Law Section and Program. And we will start by again welcoming you and to take a roll of our council members and executive staff. So I'll start, or executive members. So we'll start with Doug Duchek. Just announce yourself present.
Here. Present.
Paul Vandevert.
Present.
David Sloan. Let's see, Neil Wolke.
I don't understand the answer.
Anne Blake Dreyer.
Present.
And John Wright.
Here.
That was a here?
John Wright is here.
All right. All right. Eve Lehrman.
I just heard from Eve, and she's having trouble signing in, James.
Okay. We'll go to Alexandra Stan.
James, this is Reinhard. Alexandra emailed this morning and excused herself for work reasons.
All right. Let's see. We'll run to the to Aida Dismondi.
Good morning, I'm present.
Okay. Aida Dismondi, John Wright, Anne Blake Dreyer, Paul Vandevert, Doug. Also, we have Bettina.
I'm here.
Bettina Schlossberg is present. And I called out for Neil before. Has Neil joined? How about Robert Rothberg? Bob?
We can probably, excuse me, James, we can probably get the list of the people at the site where you click for participants. Maybe the person helping can print that out or take a shot, and then we give us the participants now.
Bettina, I can hear about every third word you're saying. I'm sorry. Can you repeat what you said?
What I understand, if by looking at the list of participants on your right, there we have all the people that are on the call at this time. Maybe we can get some help to do this. I mean,
if we're going to take roll, we need to have an affirmative announcement that they're there,
okay,
either by photo or voice. I don't think the list is going to be useful for our verification of a quorum.
Just an idea.
This is Reinhard speaking. Just to correct respectfully the name, it's Robert Rothman, not Rothberg.
That I said Rothman. Did I?
I understood differently, but that's fine.
Yeah, I know Bob. But I haven't had as much coffee as I normally do, so. All right. So we have our executive committee. And with the council members present, we need to have the secretary announce a quorum if available. So a quorum is half of the council.
James, I'm just counting.
I've
Reinhardt.
lost audio and pictures. I've lost audio and pictures, so I'm on by phone now. Has anybody else lost the audio and the pictures?
It looks like Bettina has.
Yeah.
Aida is not on audio. Doug is no longer on video.
Yeah, I've lost video. But I can hear, so I don't need to see my face. It doesn't bother me. But for some reason, it crashed after a good start.
James, coming back to your request to the secretary, since I'm still secretary, I would like to announce that we have 9 council members present, which is more than half of the members of the council. So with that, we have a quorum.
All right, then. With the suggestion of a quorum and the call of the roll, we'll move right away to approval of the agenda. Has everyone had an opportunity on the council to review the agenda for the meeting today?
Yes.
Yes, I move its adoption.
Do I have a second?
I second the adoption.
All right, then we'll go to a vote. All in favor of approving the agenda as presented, say aye.
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 All opposed? So the agenda is approved. And we'll move right away to the review and approval of the minutes of the prior meeting, which were sent out by Reinhardt to the council by in time for our review. So has everyone had opportunity to look at the minutes as distributed?
Yes, and the date in the second line is incorrect. It should be March 25th, not January 25th.
For that meeting.
Yes.
You are correct. I apologize for the mistake and I will correct it.
Well, we forgive you.
Thank you.
All right, then. With the correction assumed to be made in the presented written approved minutes, can we vote on the approval of the minutes as distributed for the prior
Mr. Chair?
Yes,
Mr.
sir.
Chair?
Mr. Duchek.
Rather than say Douglas Duchek was missing, which many people probably think is a continual and constant problem, perhaps not present would be a better word.
I noticed that, and it's up to the secretary how he prefers to categorize your absence.
I know, and I wasn't there. I thought maybe I joined that meeting late, but Reinhardt has reminded me that I did miss the meeting, and we talked about it 2 days later.
Reinhardt, this is an informal request for you to soften your language on the lack of attendance by Mr. Duchek at the prior meeting.
Well, I will be most happy to change the wording, but let me explain that it was not meant to be harsh. It was meant to be thoughtful because we were missing you, Doug.
Well, I will go with whatever you, Mr. Secretary, thinks is the most apt description of my not being there to kibitz.
I think due to the fact, Doug, that you have not been missing for 8 years, as you explained to me, you will not have missed the last one. You probably were just not present. And I will correct it.
I bow to your expertise, Mr. Secretary.
All right, with the
Thank you, Mr.
with the
Chair.
two revisions stated, we should entertain a motion to approve the minutes as to be revised.
I move to approve the minutes as to be revised.
All right, John, thank you. And do I have a second?
I'll second, even though I wasn't present.
But you are now, and for Robert's rules, that's what's critical.
Okay.
So
I
with the second, we'll vote on the approval of the minutes. All in favor?
Aye.
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 Any opposed? All right, so the minutes are approved as presented with the revisions to be made before final entry. Now I will turn over the report to Ms. Bettina Schlossberg to review our financials.
Okay, here I am. I sent the financials yesterday. The last ones we get is for the year 2019, 2020. As you can see, because of my careful administration of funds, we have a lot more money than last year, and we spent a lot less than we did last year. No, don't include this, Reinhardt, in the minutes. I was just kidding. There hasn't been much expenses, unfortunately, this year. Hopefully next year we will be able to make up for them and spend a lot of money in meetings. But you can see from the general ledger that most of the expenses were made for our November annual meeting last year. And then there's the minimum expenditures in what we pay the state bar for keeping our section up and running. And then in the what's not a profit loss. In the comparison of years, you will see that we have almost 10 grand more this year. That's what I was referring originally to. But it's basically not because I was really careful with the money and I know what I'm doing. It was basically because we haven't spent anything because we couldn't leave our houses. So that's for it. I had a list of...
It's true that in most years we would have had a large supply of wine and beer for the program. So
yes, and some restaurant bills. But anyway, is there a question? I'm sorry.
I had a question, Mr. Chair.
Yes,
Under
Doug.
revenue, how do we have a negative $70 of revenue? Is that meant to be a refund note, or how do you have negative revenue?
I think for the period in question, that this was not a total of our revenue for the year, but a subtraction of someone who had gotten an expense report covered, if I recall, Bettina. Do you want to address it? But this does not show our annual revenue for the full year.
I don't remember having any expense in August, and this is for the section dues. So maybe somebody had paid in error, and then they decided they didn't want to participate in our awesome.
So what was the revenue received for the calendar bar year for this section?
12,530.
Yeah,
Again.
you know, that's that you show 12,460, and then you have that $70. So that That
That's
negative 70 just is kind of a funny thing. I just couldn't figure out how you had negative revenue, but
Well,
anyway.
it's not revenue, correct? It's incorrectly categorized as revenue section unless the revenue attributed was wrongfully attributed and then debited. That's the only
okay, thank you.
logical.
We
Yeah.
probably would need to look into the previous year to see if, oh, there you have the 17. Oh, I get it. Doug, come back.
Yeah.
If you look at the year-to-date, August 2019, you have student dues, $70. And so it's probably a carryover of that, and there are no student dues. So probably, I don't know if it's affiliate dues, students don't pay. So probably they had some students pay and then they gave the money back, because that 70 is like 235s that we have for an affiliate in August 2020. So I'm guessing it's some messing up of the classification of membership, whether it's affiliate or a student. But if you want me to go
And I would say in
detail,
general too that our revenues are excuse me, a little bit below what we see in most years, and I think part of the activity issue will affect membership unless it's picked up quite rapidly, because we had very good membership with activity, and those two go hand in hand. So for the future executive council and chair, just to keep in mind, the revenue shown is not something that we should celebrate.
Yeah, we've been in the 20,000s before, haven't we?
Close. Yeah, close.
Yeah, close. Yeah, close. Yeah, not quite, but yeah.
So should we...
it doesn't matter how much money you have. What it matters is if you have money, how much of that you can spend. And because this year we cannot spend anything, then it's more than enough.
and I'm not doing anything but equating the total amount of revenue to the health of the section moving forward into the future. Any other comments on the treasurer's report?
Thank you for the explanation, guys. Appreciate it.
Do you want me to go into it with the state bar?
No,
Okay.
but that's up to Elliot.
Bettina, this is Reinhard. One question I have, or maybe I should say it's a statement. I see in the ledger that we have not received yet the bill for the caterers still for our February meeting at Automation Alley with the Council Corps of Michigan. So
I agree. That was my responsibility, and I've contacted them 3 times, have not gotten an invoice. And so it's missing and unpaid. But as far as I'm concerned, as with any contractor, we have fully paid on time all our obligations. And until we receive an invoice, we have no obligation. 3 times I've contacted the brass rail for that invoice.
okay,
All right, I'm going to go into the next item, which is the chair's report. And just to quickly review last year as in totality, I had come into this position with a set of goals, and those were quickly dived into by the section before, we were diving into a concrete patio instead of a pool because of this virus. So many of the goals are unachieved, and I would confess that except for our activities related to working with other sections and the international community, our goals of both generating the excitement among our membership for programming and for increasing our social activity and membership numbers, those have been left unachieved. I do believe that the activity that we did have prior to slowing down into February for the rest of the year was quite good at integrating other sections and bringing in members of the outside international community. As you recall, we started off last year's annual meeting at the offices of Dickinson Wright with the very good program on the U.S. Mexico-Canada agreement. We had the Consul of Mexico, Senor Gonzalez Saife. We had Alyssa Tracy, the Director of International Trade for MEDC. Carlos Calderon of Clayton McCurvey, who's in charge of Mexico and Latin America. Also rounding out, we had prior chair Laura Phillip, Cindy Tajam Cherniak, a lawyer from Toronto, and Mark High of Dickinson Wright, rounding out that program, which I thought was really a good one. We had on October 10, a special meeting of the council regarding World Trade Week, and we had brought in to help us out with World Trade Week Paul Vandevert, who had volunteered to work with that until that was canceled. That was just the beginning of the upcoming period, but in November we were able to have a very high-level meeting and program regarding privacy protection and the relation to international law obligations and requirements for documentation. That was a very good program that both Bettina Schlossberg and Bob Rothman put together and had with other high-level experts in privacy and immigration law. That was at Wayne State University Law School on November 20. February 12, we had Global Perspectives on Trade, and it was a council meeting that was held in conjunction with a social program with the Consular Corps of Michigan in Detroit. That was Reinhardt's organization that made that a successful and very fun program. So we appreciated all of that, which again came to a pretty fast close after that, as we were already discussing and joking about the virus during that entire February program, not knowing what awaited us for what has proven to be a terrible rest of 2020. And I saw a great cartoon about someone showing December 31, ready to celebrate, flipping the calendar and seeing December 32, 2020, and looking quite disappointed. So I do want to say that the goals that I had for the section coming in, I think are generally universally desired, and the most important and final one was to have the highest level educational and professional programming that we could present, along with the subsequent sidelining of that goal, which is to have fun, to get together and have fun with ourselves and other international and professional groups, including other sections. I would say that it was quite a rewarding period to run up and help with the section's activities, and I appreciated and was pleased with the trust that was given. And with that, I'll end the chair's report and move into our next agenda item,
James,
which is
I apologize. It's Reinhard. Would you also want to mention the June event?
We did have a June event. It was actually a very good webinar event. The June program was put together entirely by Yves Lehrman, and we had a very high level program regarding Michigan and the trade aspects of international issues. And we had the head of the Michigan Manufacturers Association. We had another expert from the U.S. Department of Commerce International Trade Association. And as I recall off the top of my head, it was not only well attended, we had over, Reinhard, if I recall, over 180 people registered and attended from around the world.
We had actually over 300 people from 20 countries in the world, and in the United States, it was as far as Hawaii.
And it was an excellent program for those of you who were able to plug in. So the programming didn't stop, although, you know, it felt like it was more setting up and having the fun that we normally do was not available. Eva, I wanted to thank you for that program as well, because it was an excellent academic program. So let's move on then to the report of the nominating committee. The nominating committee is the executive council, and we put together a slate of new officers. Under our bylaws, the incoming chair is automatically ascended to the chair of the section. For the remaining officers, the nominating committee has put forward for chair-elect Reinhard Lemke, and for secretary Bettina Schlossberg, for treasurer Aida Dismondi, who is a current council member. We have also nominations for additional new council members, and that would be Aaron Ogletree, who many of you may remember having been active in the section with our trade committee during the period when Laura Phillip was chair and prior as well. We have also on the slate for council Elizabeth Storm is an attorney in Petoskey, Michigan, involved in international work. And also Omar Sawaf, who is an attorney who works at Randy Wright's firm. If you remember, Randy is the former chair of the section as well. And Omar's resume is quite impressive, as well as the other members who have been nominated. I'm going to let Reinhard have a word and see if he wants to give a little bit of further rounding of the committee presentation.
James, I'm not sure if I understand your question. What exactly you ask from me?
Whether or not your participation on the executive nominating committee, you have any other comments on the presentation of candidates?
No, actually, I don't. I think we found a group of not only very willing, but very prepared and highly educated and experienced individuals that I support.
Elliot? did you have any comments?
Only to thank those people whom we have nominated for their willingness and the ideas that they have already advanced, and I look forward to their contributions to the program and other activities of this council. Thank you.
Well, then I will allow a minute for Aaron or Liz or Omar to say a word to just introduce and welcome themselves. We'll start with, do we have Aaron on? Aaron appears not to be with us. Liz?
Thank you. Can you all hear me? Or James?
Yes.
Great. Yes, thank you very much to Elliot and to the rest of the council and all the work that they've put together. This is going to be a great group to be a part of. And I look forward to working with the new secretary, Bettina, and Reinhard and Aida on the agenda for 2021. So thank you. Hopefully we'll have a lot of great activities and events just like we did in person, virtually. So it's great to see everybody.
And I think it's always good to have some geographic variance in our active council members as well.
As you know, I am looking forward in this section, not all sections. Due process still matters. I want to see all of you in person. But rurally, as you know, in northern Michigan, it will be a great brown bag lunch experience. Thank you for the hors d'oeuvres.
And Omar Sawaf?
Yeah, hi. Hello.
Hi.
Can you hear me?
How's everything at Barry Mormon?
Fantastic. I've really enjoyed working with Brandy, who is just amazing experience. He's been really, really good to work with. John, who's also on the call, has been great to bounce ideas off of as well. So thank you, John, as well. Thank you for the consideration. I appreciate it. I've had a long history or interest in international law. I was overseas for years and bouncing around between Dubai, Hong Kong, and elsewhere. And I just moved back to Michigan a couple of years ago. I'm from Grosse Pointe originally. I really enjoy the practice area, and I'm excited to work with all of you.
Well, I saw you were with the premier law firm in Dubai. Al-Tamimi and Company is quite well known to those of us who had a lot of activity there. So,
yeah, no, it was not a strange story. I actually applied there. I was going to Dubai on vacation, applied there kind of as a joke, not thinking, not even really knowing if law was practiced in English there at the time. I got an interview while flying. I got a request to meet from the head of corporate real estate there, and I met. She actually had just attended a seminar at GW where I graduated, which was the connection, which is why she reached out to me, and I got a job on the spot and ended up quitting my job in DC and moving to Dubai without much thought, to be honest.
That's amazing.
7 years.
All right. Well, we're glad to have you on the slate. And at this time, I'll entertain a motion to vote on the slate, including officers and new council members.
So moved.
Do I have a second?
Second.
Any debate? All right, then, having heard from the new council members coming in, having seen the officers to be installed in their new positions, then we'll now have a vote on the slate as presented by the nominating committee. All in favor?
Mr. Reyes,
Yes.
to interrupt quickly, Aaron Ogletree just posted a message that he is here.
Ah, okay. We cannot hear him.
He sent a message in the chat that he is present.
Yes, I just heard you, Aaron, but we're going to go ahead with the vote. We're in the middle of a vote, so I already indicated your experience with the section before you're joining, so we're going to carry on and push forward. All in favor of the slate as presented by the nominating committee?
Aye.
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 Opposed? All right, then the slate carries. The new executive council consists of Elliot Church, chair, Reinhard Lemke, chair-elect, Ina Schlossberg, secretary, and Aida Dismondi, treasurer. The new council members include Aaron Ogletree, Elizabeth Storm, and Omar Sawaf. With that, I thank you all. I'm turning the meeting over to Elliot Church, your new chair.
Thank you, James. And let me welcome the new council members and Aida as treasurer. It will be a delight to work with you. I've enjoyed talking with you recently, and I'm excited about what we'll accomplish together this year. We have a very interesting program today, and I don't want to delay it. Therefore, my comments will be very abbreviated, and then we will move on. So to begin with, let me thank James Reyes for his exemplary leadership this year. I like James as a leader, and I also like him as a person. I've had the opportunity to socialize with him on a few occasions, and he's funny, he's insightful, he's well educated, well traveled. He is all the things, in fact, that characterize the people who are members of this section. And it's why I like to be a member of this section. It is truly the most interesting section of the state bar, for all the reasons I just said. You all have these interesting and expansive personalities. You tend to be gregarious and ambitious and willing to pitch in. So thank you for those qualities. And James, thank you for being an example of those qualities and for really directing this section in a way that I've enjoyed this past year. I want to also thank Douglas Duchek and Robert Rothman, who are coming to the end of in fact, they have just finished their terms as council members. I would refer to them as senior council members for two reasons. They've been around in the practice of law a long time, and they've been around in this section for a long time. And as a result, they always have insightful comments, and they see things from a perspective that I don't sometimes, and it's always enlightening. So I appreciate their contributions and thank them. I want to also mention that John Wright is here today. John has served on the council for the past 3 years, I believe, and has been willing to pitch in and done some things for us that others probably haven't had the aptitude to do, like setting up our social media accounts and doing some investigation into the ways that we can interact electronically with our section members and each other. I want to thank John for his ideas and for being responsive. I've often called John and asked his opinion or asked him to do something, and he's always been willing. So thank you, John. And you will not be continuing as a council member at your own request because of family obligations. So thank you, and we wish you well. And you are, of course, invited to continue participating in any role that you choose. Alexandra Stan, who has been a council member, will also not be renewing or continuing as a council member because of work and imminent work relocation that will take her to California. So we wish her well. We're excited at her new opportunity, and I've enjoyed knowing her, and she's been an energetic vocal contributor in past meetings. James, I want to mention one other thing with respect to you, and that is you will be receiving in the mail at your office soon an honorary gavel, which is our gift to you as a section. And in fact, I received an email from, I think, Jennifer Hatter at the State Bar asking me to approve the inscription, which I approved. And so we give that to you as a way of remembering what you've done, and hopefully that you will find it as a nice souvenir of your time and service here.
At the risk of violating the emoluments clause, I thank you.
Okay. As for the agenda for this year, James indicated that one of the things we do here is have fun together, and that's true. It will admittedly be less fun this year. And why is it? It's because we're all restricted in some way from meeting each other in person, but we'll do our best to have fun anyway. And we'll have to be intentional about networking. And so what that requires is reaching out to each other personally. We have each other's phone numbers. Let's feel free to call and talk about how to move things forward. The thing we can focus on ambitiously is education. The purposes of this council are two: education and networking. And we're going to focus more on education given our global health context here. What will we be focusing on? Two things. One, core competencies. So James referred to the last annual meeting, and there Bruce Stellan was present, and he spoke eloquently about what the core competencies are in international law. And they are exports, distribution and sales, licensing, customs, tax, joint ventures, direct investment, compliance, international dispute resolution, cross-cultural awareness, among others. And that is a list of things that Bruce seeded for us, and that list has been fleshed out in conversations with Omar Swaff, among others, James Reyes, Reinhard Lemke, Aida Desmondi, and Bettina Schlossberg. So thank you for your contributions. But we're going to focus on that. We are going to have programs that are relevant to core competencies. And the other theme will be technology in international law. And that is because that is my background. So each chair brings their own personality to the equation, and hopefully we add things that are both interesting and useful in the practice of international law. My background is in technology law. And for that reason, this program, I hope, will demonstrate some of the things we want to bring to the section and to the Bar Association as a whole this year. There will be 5 meetings this year. At a minimum, those are anticipated to be on December 2, January 27, March 24, and May 12. You will receive notices about those. And I look forward to conversing with each of you about the program.
For the minutes.
Yes, October 14, which is today. December 2, January 27, March 24, and May 12. And with that, I thank you, and I am pleased to be the chair. It's a privilege. Feel free to reach out to me at any time if you have questions, comments, or feedback. I would like to move on to our program. And so I will entertain a motion. Well, actually, I'll entertain a motion. I guess I don't have to entertain a motion to finish my own comments, but I will entertain a motion to move forward to new business. Is there a motion? Okay. In that event, we will simply, I don't think I heard a motion to open the discussion for new business. Is there one?
Moved.
Okay. Moved and seconded, please.
Second.
Okay. Then is there any new business? And if there is, I would like to make it short. Second call for new business. If not, feel free to reach out to anyone on the Executive Council personally via email or telephone, and we can add those items to subsequent agendas. I'll entertain a motion to close new business.
A motion.
Seconded, please. Okay, it's been motioned and seconded. James, do I need a vote on that or not?
No, you don't need a vote to move to various stages of the agenda items.
Okay, thank you then. In that case, I believe I do need a motion to adjourn.
Correct.
I will entertain a motion to adjourn, please.
So move.
Okay, and seconded, please?
Second.
I'll second.
Great. James, do I need a vote on that or not?
You do, but it's pretty perfunctory. But yes.
Okay. All in favor of adjourning, please.
Aye.
Say aye.
Aye.
And any nays?
Aye.
Okay. Then we are adjourned. And so we will move on to the program. We are privileged to have Christopher Evans, a London-based attorney who I think should instead be referred to as a barrister and solicitor. And I will let Christopher Evans explain the difference between those two terms and when you might want to engage one and when you might want to engage the other. We have Christopher Evans here from the Drusus Law Firm because of his relationship with James Reyes. So James reached out to Christopher and asked if he could say a few things about the practice of law in London. The reason we're doing that is because our other speaker, Shrey Agarwal, who will be speaking soon, probably shortly after noon, in our main program, he is also from London. And so one thing that we are availing ourselves this year is the opportunity to engage speakers from a long way off. So this is one thing that present circumstances do permit and in fact encourage. So we're privileged to have Christopher Evans here. James Reyes, would you like to say anything by way of introduction before Christopher begins his talk?
Well, Christopher and I have met quite a long time ago, both in bar association matters and in professional terms. Christopher was a highly regarded solicitor who I discovered was also a barrister. And he will explain all of those distinctions. But I just want to say that among the professionals I've worked with around the world, he is one that I regard as one of the most rewarding that I've had an occasion to work with repeatedly. So here he is, Christopher Evans of the Drusus Law Firm. If any of you know Latin and Roman history, Drusus was a famous family name from the Roman Empire. I'm not sure if that's how you're
mainly the women. Drusilla.
Christopher, before you launch in, let's reset timetables here to ensure you have enough time. So why don't you plan to talk between now and finishing up no later than 12:05? Then we will take a 5-minute break so everyone can get out of their chair and relax their eyes. And then we'll come back at 12:10 and we'll begin with Shrey's talk on cross-border AI. Does that sound fair, Chris and Shrey?
Yes. Can you hear me?
Yes. Take it away, Christopher. Thank you.
Well, first of all, James, the check's in the post. Thank you very much. I've known James for about 30 years now and also been impressed and delighted to have the experience of him as a friend, also as a professional colleague. I've only known Elliot for about 30 minutes, but I've also been impressed by his enthusiasm and professionalism. I'm delighted to have the opportunity to talk to you today. And may I say, wear a tie for the first time in 6 months and a shirt, but not suit trousers. Well, a little bit about me. As James has said, I'm a barrister and a solicitor, which is fairly unusual in the UK because as many of you may know, we have a split profession. I'll talk about that a little bit in a minute. I'm presently a consultant with the law firm Drusus. In fact, its previous name was Drusus and Attlee. And those of you with a knowledge of early 20th century British political history will know that Clement Attlee was a former Prime Minister of the UK, and his grandson was a partner in the firm. But in the modern way in the UK, law firms have decided to reduce their names almost monosyllabic, so now we're just known as Drusus. We're a full-service commercial law firm with about 80 lawyers, and providing legal services in the UK for about 250 years, which makes us probably the longest firm based in the City of London. Again, those who've travelled to London may know that London actually is 2 cities. It's the City of London, which the closest we'd have is, I guess, in New York, the financial district, and there's the City of Westminster. So actually it's a city of 2 halves, and I work in the financial district, the City of London. I want to say a few words about UK law, which you may know, and I apologise for repeating the obvious, but sometimes it's worth reminding, going back to basics. I do get this in contracts I see from foreign lawyers, including from the US. We don't have a federal state system of law as you do in the United States, but there is some similarities in our legal systems. Overall, there's something called UK law, which covers all the countries of the United Kingdom. And just to remind you, we have 4 countries. There's England, there's Wales, there's Scotland, and there's Northern Ireland. Although, again, those of you who follow local politics know Scotland is trying to extract itself from the United Kingdom and causing some difficulties for us. So we have
Christopher, do you have slides that you want to display?
Excuse me?
Do you have slides that you want to display?
I have slides, but I don't know the technical means to display them, Elliot.
Okay.
So if you could share them with the delegates, that would be really helpful.
Thomas, do you have a copy of Christopher Evans' slides?
Let me check my email and see if I do.
Okay. If you do, feel free to share them when you encounter them. Christopher, thank you, and please proceed, and we'll bring those up as soon as we have them.
Wonderful. So as I say, there is some federalism in the or devolution in the UK, but primarily the major pieces of law, tax law, employment law, company law, are UK-wide, but there are local laws dealing with other areas. And particularly, I want to point out contract law, which some of you will have come across and show in your professional practices. You'll often see at the end of let's call it British contracts, the phrase, this contract is subject to the law of England and Wales. As opposed to the contract law, they're identical. And English and Welsh law, contract law, is different from Scots law. Again, those of you who may do work in Scotland have to be aware that the Scottish legal system is closer to the civil law system you see in many European countries and is very different in 2 areas, property and contracts. So please don't add to any of your contracts, this contract is subject to the law of the UK, because it doesn't exist. It's England and Wales or Scotland. So the summary there is to, when you're doing contracts with UK entities, is just to be aware that most of the laws which will attract to the contract or connect to the contract will be UK law and therefore the same in all the 4 countries. But in relation to contracts and areas of devolution, devolved powers, you would need to be aware that there are local laws which may make a difference. So that's a quick canter through the UK constitutional legal system. Let me talk about access to UK law. And I want to talk about barristers and solicitors. As James said at the beginning, I'm a qualified barrister and a qualified solicitor. It's a different system, of course, than you have in the US, although I believe you have attorneys and trial attorneys, but forgive me if I'm ignorant about that. But in the UK, it is different. And it's a difference which goes back hundreds of years. The bar has an ancient history going back to the 13th century. The original lawyers were barristers who would plead before the king's courts. And over time, and with the development of the Industrial Revolution, there became a demand for lawyers who didn't have to go to court. And that created the profession of solicitors. The essential difference is that barristers advise on very narrow pieces of law or they attend the courts and plead before the courts. Mrs. Thatcher at one point wanted to try and get the professions fused, which she failed because they're too entrenched. But what she did achieve was allowing solicitors to have rights to appear in the higher courts. When I started to practice a long time ago, barristers had a monopoly rights in all the courts, in all the higher courts. Solicitors couldn't attend them. And even though solicitors do have rights in the higher courts, they don't tend to exercise them. So if you do get involved, or your clients get involved in litigation in the UK, from the High Court, Court of Appeal, or the Supreme Court, you're more than likely to be using a barrister to plead your case. I'm just going down through my notes and my little pictures of barristers you may see. By the way, the wig's very uncomfortable. It's horsehair, and in the summer it's really it's a pain to wear. But for some reason, barristers like to keep them. Every couple of years, they're given the option to get rid of them, but they keep them. Some exciting's happened to my screen now. I'm sure it means something to somebody. So, just to finish off on barristers and solicitors, if you need advice on business legal issues, then you would generally go to a solicitor first who's specialised in that particular area. However, if you're contemplating litigation, then you can go direct to a barrister. There is a dispensation allowing foreign companies and foreign lawyers to go direct to barristers without having to go through solicitors. But the biggest issue you may find is choosing the right barrister, and that can be a bit of a minefield. Barristers are managed by clerks. Clerks are like Hollywood agents with the same morals and behaviours, but not the glamour. And they are the gatekeepers to the barristers. So if you are thinking about using a barrister, do speak to a local solicitor to get get a sense of how best to do that. Otherwise, you may find you're paying over the odds. Now, I'm conscious I'm coming up to, in the UK now, it's 17:01, which I think is 12:01 in the US. So I've got a couple of minutes to finish off. I just want to talk a bit about the future of UK law. Again, those of you following what's happening in the newspapers will know we're in a very difficult and awkward dispute with Europe over Brexit and our future relationship with Europe. Currently, there are intense negotiations going on between our negotiators and Barnier from the Commission, and they're not going particularly well. Just to remind you all, the UK has left the European Union. Brexit has happened. What we're going through now is a transition period, which carries on to the end of the year. And unless we agree a deal with Europe by the 31st of December, on the 1st of January 2021, we'll be conducting our relations with Europe through WTO rules, which is a nightmare on many levels. However, one of the things that it has given the opportunity to the UK, now it's exited Europe, is to create bilateral trade deals with major countries. And of course, you may have read that there have been some initial negotiations between our respective governments on a future trade deal between us. And certainly from our government's perspective, it would be really helpful and valuable and a great win if there could be a relatively quick US trade deal. Any comments on that would be much appreciated. So just to finish off on the European side of the future of UK law will remain the same. However, it'll start to differ from European law. Currently, those of you know, many of our laws, of course, are European laws, which have been implanted in the UK by virtue of our signature of the European Communities Act in 1972. Well, all that's changing. So from next year, you'll begin to see differences between the UK position and European position on many laws. So again, those of you who are doing or advising on transactions in Europe will have to wear now the effectively two parallel legal systems. The European legal system and how the UK fits into that, and of course separately, and as always the case, local legal systems depending on laws which are not purely European. So I think I've come to the end of my time now. I would welcome any questions or any comments. Otherwise, thank you for the opportunity for speaking in front of you today.
Questions for Christopher? Thank you, Christopher. Any questions?
I had a question. Most times when we're doing international transactions, in my experience, the client and counsel would opt for arbitration over local courts for enforcement reasons, what have you. And question is, in your experience, do people look to barristers to pursue and litigate arbitration claims in the same way they would the courts? I used to work at Herbert Smith in Dubai, and occasionally those solicitors would try their hand at arbitration. I don't know if they were particularly good at it, but they would try it out. And I'm just wondering, in your experience, is it still worth going to a barrister for arbitration?
That's a very good question. in fact, when arbitration became more popular, I guess from the 70s and 80s, it was seen in the UK as an opportunity for cheaper route to litigation. Litigation in the UK is expensive. I can't hide from that. However, arbitration has been kidnapped by barristers and solicitors. So the structure you would see in the courts is the same in arbitrations. So to answer your question, you would go to a barrister to assist you in an arbitration. You're quite right, there are some of the bigger firms do have in-house advocates, some quite good ones. But overall, the specialists and those with the most experience are at the bar, are barristers. So I personally would instruct a barrister if I had a litigation, either in open court or in an arbitration.
Thank you for that.
Other questions for Christopher?
Yeah, I have a question. I heard that the UK, although it has pulled out of the European Union, still participates in certain European institutions, for example, the European Patent Office. Do you have any information as to whether essentially these European patents are still enforceable in the UK, and whether the European patent regime is still even relevant for the UK? And how does that impact the practice of, either a barrister or solicitor? Do they still need to be licensed in order to practice before the EPO? And defines the enforceability of those patents.
Can I take the last part of that question first? There currently is a dispute it's unclear between the European Commission and the UK government about the reciprocal recognition of rights before tribunals and the courts. And that has been caught up in the general negotiations taking place, the posturing taking place between the UK government and the European Commission. So it's not clear. I say it's not clear yet. In terms of the first part of your question about the relevance of, say, European intellectual property law in the UK, that's intensely complex. And again, it's still caught up in the negotiations. And I'll be frank, it's an area in which I have some experience and some specialisms, and I'm struggling to understand exactly what's going to happen after January the 1st. So, but one of the great frustrations for my profession is the British government has left many of these issues so late, it is difficult to give cogent and sensible advice to our clients. But what I will do, what I will share with after this presentation with Elliot, some briefing notes on this question, if I may, and they can be passed around the audience. Because as I say, it's a really difficult topic and one I'm personally struggling with.
Nicholas, thank you for that question. Christopher, thank you for the answer. In the interest of time, we should move to a break. Christopher, since you have the freedom to leave us after this break, I will ask you to remain present during the break in case folks wish to chat with you during this intermission, so to speak. So why don't we all take a break? If you want to chat with Christopher, feel free, but let's all come back in 5 minutes, and then we will introduce Shrey Agrawal and begin the main program. And we're going to add some of the utility of that. So what do you do with that data when you get it somewhere? Well, you analyze it. And you analyze it in ways that are becoming increasingly sophisticated. Machine learning, the most predominant form of AI. When we talk about artificial intelligence, we're often talking about machine learning today. It depends on lots of data for training purposes, and those algorithms are more accurate the more they are trained. So this idea of aggregating data to do that is both popular and useful, and also subject to a lot of regulatory complexity. And so it's great to hear someone such as yourself, Shrey, who has some current knowledge and has looked into this and can tell us a bit about the regulations and the technology as well.
Sure.
And so I will welcome you, and please say anything else you want by way of your own introduction, and then launch into it.
Perfect. First, let me try sharing my screen and let me know once you can see my screen. Thank you so much for inviting me to this panel to speak on something which is very, very important these days. So when it comes to AI and international trade and policies and legal issues, there has been a lot of talks going around. We'll talk about that today, and we'll also introduce different solution and different tentative policies which are being discussed all across the world. Now, before doing that, let me take an opportunity to introduce myself. I'm Shrey Agarwal. I work as a data science specialist at Publicis Sapient. Along with that, I am also very active when it comes to UK and global conferences and forums where I speak on ethical AI, safe AI, fair AI, different versions of ethics and AI. I am also an avid blogger and writer and author when it comes to AI and machine learning topic and techniques. Now, today, what we are going to talk about is very, very important. And this is what I talked about a couple of days back in UN. So when you talk about cross-border AI, legal issues and technical solutions, we need to understand that the moment you cross a border, the kind of rules, regulatory requirement changes phenomenally. Not only that, the way you transact changes phenomenally too. So I'll give you a simple example. So for example, the amount of tax you pay on a transaction, on international transaction in a particular state may differ from the amount of tax you pay on an international transaction in other country. Similarly, the laws for any financial crime in a particular nation is very, very different from other nation, and may be so much different from some other nation that you may not be even prosecuted for a crime which is seen as a very severe crime in a particular country, but you may go scot-free in some other country. So talking about all this, when we talk about cross-border trends or cross-border transaction, the most important thing here would be transactions, money, data, flow of data, etc. So let me jump into the topic directly. So how has the importance of AI increased in international trade? So if you see since 1990 to 2020, the amount of AI or amount of technology at large, which has taken a center stage in different areas, has increased phenomenally. So if you see when it comes to post-COVID world where physical interaction has got limited, you see a lot of cloud computing, machine learning, AI helping you to make decision and also tracking something which should not be done when it comes to international trade or international exchange of any kind of transactions. So given this scenario, we see that a lot of changes are coming in when it comes to AI and AI based any financial transaction. So especially with more cloud computing coming in for more, and especially companies having their centers across the world, especially people are getting more mobile in sense they are moving from one place to another, things have completely changed and the way the data is used has also changed a lot. So when it comes to data or AI, or when it comes to any kind of cross-border trade, the exchange of data takes place almost seamlessly and at an abundance. So even when the exchange of data is taking place at an abundance, we need to also understand the way the data breach happens also changes. So I have categorized the data breach into two categories. The first one is where a data breach impact the processes of an establishments in several countries. So for example, I have a company and that company is into 5 different countries across the world. And if there's a data breach where all my 5 or 3 out of 5 or 4 out of 5 centers or the companies in 3 out of 5 nations gets impacted That's one type of data breach. In simple terms, you have a multinational company, transnational company, all the companies get impacted because of some data breach or some virus or some malware or some attack on your system. That's one kind of data breach. The second is about an individual. So for example, I as an individual has some bank account in US, India, UK, Canada, and Singapore, and my data get leaked across the world. That's another kind of data breach. In the first kind of data breach, the company is attacked. In the second kind of data breach, the individual is attacked, right? And in both the cases, the attack happens across the border. So that is what we are talking about in breach or in type of data breach. Giving you some examples, a couple of years back, British Airways was fined with 180 million pounds because it was seen that some very personal information of their passengers, like name, gender, phone number, addresses, travel history, got redirected to a website or a server where it was not supposed to be redirected. And around 500,000 customers' personal information got compromised. So that's one very, very important case, because we understand the way we travel talks a lot about us, and we do share a lot of our personal information, be it our addresses, phone numbers, and other details. So that happened a couple of years back. This year, there was one more case where a company called Experian is a credit reporting company which gives you credit scores, experienced a data breach of South African people. So 24 million South African people and around 800,000 South African business entity data got exposed or leaked. And interestingly, this didn't happen in South Africa. The data got leaked outside South Africa. So there was a lot of tussle that who is responsible, since it was the data which got leaked was of South African entities, but it didn't happen in South Africa. So there was a lot of tussles when it comes to regulatory requirement and so on and so forth. Similarly, there's a company called Clearview AI, which is under surveillance or which is under controversy because they use something called a face recognition algorithm to recognize the face of people and use it for some government check purpose, maybe traffic breach or criminal offense and things like that. However, UK and Australia have reservation that these kind of data which Clearview AI is using, maybe intentionally or not intentionally, may be used for some other purpose which they are not authorized for. So these are the few kind of data breach which happens when it comes to international or cross-border trade or cross-border transactions. Similarly, there are few data privacy laws which are very, very famous or which are on the top of their game. However, when I talk about data privacy and policy, we need to understand none of them are comprehensive in itself, and not because they don't want to be comprehensive, because it's a completely new area of trade or new area of information exchange. So when it comes to new area of information exchange, we need to acknowledge the fact that the kind of data leakage which is happening has never happened before. So anybody who is drafting the policy may not have an exhaustive list of the way the data breach can happen. So every day or every hour or every minute, a new kind of data breach is happening. And thus countries are trying to incorporate those in their policy after a lot of deliberations. But having said that, there are few policies or there are few countries which are well ahead of others when it comes to data privacy. So for example, the most comprehensive is the TPP, or the new name is CPTPP, which is a Trans-Pacific Partnership, which explicitly talks about how do you govern cross-border data, especially when it comes to cross-border data to be used for any machine learning or AI or deep learning activity. So it pinpointedly, or it actually write down the rules, the regulations, the checks which needs to be maintained. Then the new one which has recently come up and is in process is Egypt's personal protection law. So cross-border transfer or sharing of personal data is completely prohibited under Egypt personal data protection law, and unless the country where the data is going outside the Egypt border guarantees a level of protection for personal data and ensures that no harm or no data leakage would happen for any data which is originating from Egypt and going somewhere else. So so in simple terms, any company using data from Egypt outside Egypt needs to be 100% accountable and responsible for what they are doing. So that's one very interesting personal law protection, personal data protection law, which is being currently drafted or being currently debated in Egypt, and which may see the light very, very soon. Similarly, China is coming out with the global initiative on data security. However, we don't have much details on Chinese global initiative on data security. But as per news and as per whatever has been the speculation, it is being said that this may be the most comprehensive policy when it comes out. However, the draft policy has a lot of overlaps with TPP and Egyptian personal data protection law and other countries. Similarly, there's something called Asia Pacific Economics Cooperation Cross-Border Privacy Rules. So again, these are the Asia Pacific Economic Cooperation Cross-Border Privacy Rules are more of suggestions and framework than legally binding regulations. So it talks about what should be done, what are the best practices and things like that, but it does not talk about penalty and fines in case of any kind of breach which happens. Then there is EU-US Privacy Shield, which has been taken off and no more does not exist. However, I wanted to put it here just for reference. The next one is US-Mexico-Canada Agreement, which also talks about banning data localization, allowing free flow of data, and promoting data privacy. But however, both the word free flow of data and data privacy does not go hand in hand in today's time. Whenever there's a free flow of data, data privacy get compromised to some extent. So it will be interesting to see how US-Mexico-Canada agreement ensures that there would be free flow of data, there would not be data localization, and still they are able to maintain data privacy. Please feel free to ask me anything during the presentation also. That would make it more interactive.
There have been a couple questions in the chat, but you've actually answered them in the course of your comments. So we haven't interjected those, but I'll keep an eye on the chat and I'll interject those questions if they're still relevant after your comments.
Sure. Thank you so much. Now, the thing is, when we talk about cross-border data, we need to understand cross-border data or data exchange is imperative in today's world, right? So I'll give you a simple example. If there's a person who have done some kind of financial crime in, say, country A, you may want to track him and his financial transaction outside that country. Or the country B may not want to have such kind of, or may want to have some kind of surveillance on that same person outside the place or outside the country where he was found having some kind of illicit transaction. So that actually gives a lot of weight to the fact that there is no way you can have data localization. Data sharing is of utmost importance and is very imperative when it comes to today's transactional world. So there are three very important areas when it comes to cross-border data analytics. One is called data sovereignty. Now, what do we mean by that? It simply says that the data should reside where it is where it was born, that the data would never go out of the location where it was generated. So if you have to use some information for some other purpose outside the location at which the data was generated, you may only use the insights, but not the data as is. So it's called future-proof assumption. Data should remain resident where it was created when stabilizing data pipelines and architecture. So whenever you are making sure that data is flowing out of the country, the data would reside at the place where it was generated, and only insights would go outside outside the jurisdiction or the regulatory jurisdiction of that country. Second one is cloud migration and multi-cloud. Now, this is again a future-proof assumption, which is very, very important. A lot of time, so for example, if I am in countries, say I'm in UK and I have my data residing in a cloud, which is being provided by, say, a company like a cloud provider A. Now I need to ensure that that same cloud provider is present in other countries where I need to use the data. Now, why do I need to do that? Because a lot of time data leakage happen when I shift my service provider. So for example, if I'm using my data in some other country where I don't have the same cloud provider which was in some other country from where the data is being transferred, there are a lot of chance of data leakage. So it says that multi-cloud approach is very, very important. Local data center should be in my country of operation, and the same data center or the same company who gave me a local data center should also be in other countries. And that's so important that company like Google, Microsoft, Azure have their presence in more than 20 to 50 countries these days, so that they are able to give their user a data center in almost all local location wherever they want to read, write, and use the data. The third one is privacy by design and privacy enhancing technology. So when we talk about privacy by design, so when you talk about data or data privacy or data leakage, the word itself is so subjective that it's very tough to define. So this concept talks about that every time you talk about data leakage, there should be a mathematical formula or a mathematical measure of data privacy and data leakage, which is very, very important. Without a mathematical formula or mathematical benchmark or threshold or a number, it would be very tough to define what is leakage and is leakage acceptable, or was the leakage acceptable or not acceptable. So these three are very, very important tools or ideas when it comes to safeguarding your cross-border data.
Sorry, when you're talking about best practices there, are those technical best practices? Are they business best practices? Mm-hmm. Could you explain a little more about the best practices?
Mix of everything. So when you talk about best practices, data sovereignty is technical plus business. So whenever you talk about technical, a business have to define what is the technical best practices they want to implement. So for example, would they like to have cloud migration, multi-cloud? Will they ensure, or would they like to make sure that all the companies or all the partners who is using the data are using the data on the same cloud sharing platform? They need to define what is the mathematical threshold of data leakage they would allow, what is the maximum threshold or maximum data privacy they can provide. So it's a combination of business and technology. No technology can be implemented without business sign off, and no business can sign off without having a technology backup to ensure that whatever they are saying or whatever they are recommending can be measured. So the only thing why do I combine business and technology together? Because technology, if combined with business, would give a sign off. Business, when combined with technology, would give a measurable outcome or a measurable point for any kind of data safeguard.
So is this a quantification of the risk? It sounds like you're saying that the risk should be quantified.
Absolutely.
And that becomes part of the bargain.
Kind of, yeah. So it has to be quantified. So for example, what percent or what kind of data leakage would be allowed? What kind of data, personal data can be allowed to be transferred? At what limit? How much noise would you add to the data? How much encryption would be done? Everything needs to be taken care. So there has to be a quantifiable measure. So it's in simple. So for example, if you go and rob a bank with 1 million, and if you rob a bank with 100 million, both are not the same crime, right? I guess it's just not that robbing a bank or stealing money and the amount of money also matters. So there is a quantifiable numbers. So everything which you do needs to have a quantifiable number against it so that it can be measured. Otherwise, by one country, the kind of leakage which happened would be okay, while by other country, that would be a very severe crime.
I understand. Thank you.
Thank you so much. Now, talking about transboundary effect of artificial intelligence. So right now, when we talk about AI or transboundary data or transboundary AI and machine learning practices, not only developers, vendors, and customers and users of algorithms are the stakeholder, but the kind of and data and machine learning output are not the two things which is under a lot of surveillance or which is under danger. There are a lot of other things which can be tagged under data privacy or transboundary or transborder data exchange. These are programming code, the simple raw code or the pseudocode or the algorithm itself, the data set on which the algorithm was trained, the outcomes of the machine learning algorithm are also very, very, very important. And if you see that these days the code are written in some other country, and it is executed on the data which is residing on some other country, and the outcome is for people of some other country, right? So what I'm trying to say that different parts of a data science life cycle is happening across the world, right? So there would be somebody, say in Asia, writing your code and training the same code is being executed in UK for people who are of South African origin, right? So when we talk about this, there are a lot of complexity when it comes to transboundary or international ways of working when it comes to data and data-based transaction. So number one, so what we see that the data or data set are transferred to machine learning system, because machine learning system would use the data to train itself. A machine learning algorithm can also be transferred where the data reside. So not only data goes to the machine learning algorithm, or there can be chances where machine learning algorithm goes to the data. The third thing is the predicted outcome of machine learning system can be applied at a distance. So for example, if there is a code written somewhere in Asia, is being trained on the data present in UK, but the output or the trained parameters of the data can be applied to users of South Africa. So what we are looking at, that there is a major challenge when it comes to talking about where the leakage happened or how do you safeguard things. Would the Indian law or would the Asian law ensure that the code is right, or would the UK government ensure the data in which the model is trained is safe, or will the South African government ensure that there is no leakage and there is no wrong decision being taken on South African customer using a code written in Asia and trained in United Kingdom? So we are looking at a lot of complexity here. So when it comes to complexity, let's talk about very interesting thing which is called federated learning. Now, before getting into federated learning, we need to understand what is differential privacy. Differential privacy in simple term is when I share my data with somebody who is using my data, and my data has something like my annual income. I add some kind of noise to my annual income. So the person using my data would never know my annual income, but would also not compromise with his insights. That, in simple words, he would be able to get the similar insight which he would have got if he would have known my exact income. But adding some noise in my income, he will never come to know my income. That's the first one. The second one is called encryption, where all the insight happens on the encrypted data itself. So, for example, if my income is say $1 per day, that amount would be encrypted into a series of numbers, and that number would carry the pattern rather than telling the person or the user or the developer or the consumer of data that my salary is $1. It will tell that, okay, Shreya Agarwal falls into a category A where the income is between this and this, or something like that. So that is what we talk about encryption. He will never be able to even see what is what's my personal data looks like. The third one is secure multi-party computation. It talks about that multi-parties would work on the same data, thus ensuring that nobody has the complete information about me. But when you put everybody together, they will have all the complete information. Thus, I am allowing you to have the complete access to my information, but no one single person would know everything about me.
Shrey, I got a question about the differential privacy. Do you have a minute?
Yeah, sure.
So is there any guidance or regulation on when the differential privacy measure is sufficient? So what I understand it to be is an alteration of the data, which, well, let's say the alteration of an individual's data within a data set, which doesn't really change the statistical summary of the data set as a whole.
Absolutely. It does not, I'll not say it does not change, it does not change it significantly.
Right? So when is it enough?
Not significantly.
How do you know if it's enough? Ideally, it sounds like we're doing this in order to preserve privacy, without removing the beneficial
information
characteristics of the data.
Absolutely.
So how do you know when you've done enough?
Yes. So there's no way you can say that it's enough or not. The only way to know is it enough or not is when it comes to business. The business decides that my privacy appetite is say 2%. So I will only allow a small noise to be added in my data. So in my data or information. So there is no benchmark number as such. The benchmark, so it depends upon what kind of use case you're talking about, what kind of data you are talking about, what is the sensitivity of information, what is the risk of leakage. So it depends upon
the use of the information really
comes in. Sorry.
I'm saying the use of the information really determines that. So, for example, if you're going for a bank loan,
absolutely,
it doesn't really care whether you make $42,000 a year or 45, but they care whether you make $300,000 a year or $2 million a year.
Absolutely.
That's what we're talking about. You're inserting a randomized epsilon in there so that you either have traceability and you can figure out who's been leaking your information.
Yes.
Or to make it so that they can't use RDBMS, which is, I guess, relational databases, to link your information up with other information that they may have.
Absolutely. So that epsilon is nothing but which is called the privacy parameter. How much privacy do you want? Right. So you are absolutely right, and that is how it happens. And depend upon the sensitivity of the data, the usage of the data, and what is the use case. we need to understand, or we need to decide how much noise would you add. For example, the way you gave an example of bank loan was completely perfect and to the point. There are many multiple examples when it comes to medical reports, treatments, criminal justice, and so on and so forth. So the kind of noise you would like to add, the kind of sensitivity you would like to see, or the kind of privacy you would like to maintain would differ from use case to use case. Yep. Anything else on this before I move forward? Okay, let's move forward. So similarly, federated learning is one technique wherein, in simple terms, there are two kind of privacy, global and local privacy, wherein think of an algorithm which is a master algorithm and think of algorithms which are slave algorithm. So the training of that algorithm happens at the device itself where the data resides, and the result or the insight or the parameters of training are sent to the master algorithm, which combines everything and gives the output. So in simple terms, it does not, so it uses all the insight or information from all your devices, but do not have access to the data where it resides, while the data where it is trained is not sent outside the technology or the device from where it is being, or where it is generated.
So can you indulge me one question? So how would you do like back propagation training if you don't really have the information to adjust your multi-level perceptron, for example?
Okay, so you will do it at locally. You'll do it at local device itself. You will not use all the data combined together.
Oh, so you're doing it in batches, is what you're saying?
Basically batches, but you're not moving the data out of the place where it's risky.
So the actual data is not moved, but you get the back propagation correction factors, and those are the ones that are exported back to the.
Absolutely. The model gets updated every time you train the model at the device and you propagate the parameters back to the main model.
Got it. So what it really entails is the export of your main application to the local area, the training using the local data in that now local application, and then the re-export of your application and its associated
for
back
example,
propagation factors.
the way you use your phone, Android phone, the machine learning algorithm is executed on your phone, on your data, and only the output or the insights are sent to Google, which combine all the data from all different places and creates a recommendation engine. So, for example, GPS, Google Maps, only it does not talk about what is your exact location. It talks about, on average, what has been the location of 1,000 mobile phones in that area and how are they moving. Send it to Google, and then Google tells you, oh, there's a traffic, there's no traffic, something like that. Okay. Moving forward, this is the next part of the entire process. So when we talk about data privacy or ethical practices in AI, the four very important terms are secure, accountable, fair, and explainable, and I call it SAFE. So secure is what we have been talking about: data privacy, federated learning, the laws around it. Accountable talks about something which need to be accountable for the output. So for example, if you are making a model and it's being utilized for different pockets of population across the world, you should be accountable in sense that it is applicable to different population of the world or pockets of population across the world always. So it should not be that the model is doing very, very good in America, but the same model had started decaying, or the performance of that model start decaying in some other countries, say Africa or Australia. So that is accountability. Accountability says that you need to ensure that the distribution of the data on which model was trained, the output of the data, the accuracy of the data And other important metrics on which the model was given a sign off is maintained across the world for all different pocket of population. Now that's what is accountability. What is fairness? One of the most important topic when it comes to cross-border and even in-house data munching or data analysis or any kind of data science is that you should not be allowed, or the machine learning algorithm should not be allowed to do any kind of discrimination based on protective features. Now, those protected features can be gender, race, nationality, income, zip codes, place where you reside, your family history, and so on and so forth. So the algorithm should be fair in all terms for all different societal attributes or societal population. It should not discriminate or should not give loans or should not be better algorithm for men than women when it comes to, say, giving a loan or taking an insurance premium and so on and so forth. Explainable is you should be able to tell me why was that decision taken. So for example, you should be able to tell me that if I has been denied a loan, why I was denied the loan, and what should I have done to ensure that I would not have been denied the loan. So explainability talks about reason and counterfactuals both. So these are the four important pillars of secure, accountable, fair, and explainable AI. In fair AI, I'll give you one simple example which I always come across. So when, for example, if you are giving loan to Shreya Agarwal, being married and male, you should also have been, the loan should also have been approved if Shreya Agarwal was female and not married. Just by changing the protected attribute, the decision should not have changed. The decision should have remained the same because all other factors which governs the decision should be independent of my protected feature, be it gender, race, or marital status. So I'll not deep dive here. What I've done is I'm trying to show that you don't have to change the process, but you have to superimpose the safe AI concept on the current process itself. This is a very simple roadmap where we are talking about combining human intervention with machine intervention. That is technology with human checks and balances at every place. And on the left-hand side, we talk about how the data should flow, how do you prioritize cybersecurity or data privacy, how do you prioritize data portability, data transfer, or exchange of data. Then you talk about what kind of protection you require. We talked about data privacy, data protection techniques. Then we talked about how do you create accountability, which again we talked about, and how do you ensure that every international stakeholder has proper understanding of what kind of accountability they need to maintain when it comes to data they are using. And then future proof of policy environment, which we talked about, data sovereignty, multi-cloud approach, and privacy by design and privacy enabling technologies. So these are few things which are very, very important. Now, before I close my talk, let's talk about something which is very, very interesting, which is the 4 points which I believe are very, very important. So we do understand that no one nation can come out with AI-based cross-border data flows. Forums like World Economic Forums, United Nations, or WTO needs to sit together and come out with a policy which is transnational and can be practiced across the world. Countries are just beginning to find out the flaws in their data exchange or international trades, especially when it comes to usage of data by AI. They are still figuring out who is responsible for any kind of misuse, mishandle, or data leakage, or any kind of misusage of data by an AI-based system. Countries are also trying to come out with policies which will ensure that you have an incentive for data accountability and data privacy by either giving some kind of incentive or imposing some kind of fines when it comes to any kind of breach to data privacy and data policies. The fourth one is their countries are also carefully monitoring how their rules and trade strategies and bilateral, trilateral, multilateral policies can have an integration with data utilization in AI, and how would they monitor how is the data being used by any machine learning or AI when it comes to cross-border trade or cross-border exchange of data. That would be all from my end, and I'm open to any questions here, please.
Oh, thank you so much, Shrey. Are there questions for Shrey? I'll begin by thanking Nicholas for your interesting questions about how the process works, especially the federated learning. I have a question for you, Shrey, which is this: do you think that data should be subject to tariffs?
Sorry, subject to?
Tariffs. So tariffs are an issue today. Duties, the taxes on things that leave one country and enter another. To my knowledge, there aren't tariffs on data, but should there be? And I'm inspired to ask this question because of your last slide, which said something about offering a comparative advantage or establishing a comparative advantage, and that's done in the trade of physical goods by tariffs. We have a tariff on imports. We have things like that. What do you think? Do you think that that's something that should be applied in the data?
Tariff, the moment you put tariff, there would be more leakage of data. People would find out way to smuggle data the way you smuggle goods to avoid tariffs. I would say that rather than having tariff, had some incentive for data protection, have some fine for data breach, right? So for example, so when you do international trade, and when you are, so there are a lot of incentives, tax incentives and fines when there's something which you do right and wrong. So those kind of things are more important. When we're talking about free trade agreements or free flow of data, tariffs would be something very, very stringent. And tariffs would lead or encourage people to find ways in which they can avoid tariffs. So let's have incentives and fine so that they can put right checks and balances.
There's another question in the chat. Nicholas, do you want to introduce your question, or do you want me to read it?
I can say it. So I've been tracking the different privacy regimes with respect to consumer data. And, for example, India came out with one. China came out with a very comprehensive one. There's the famous European GDPR and so on. And more I'm seeing that there's very little concern by these sovereigns for the extraterritorial effect of their laws. And you end up getting things like Schrems 2, where they think they have a deal and they may not have a deal and so on. So the long and short is, do you see that practicing in the use of this AI over transborder, essentially over in a transborder fashion, will it become impossible over time with these?
Not impossible. It will become tough, and that is where I was suggesting that there has to be a global policy rather than a local policy. So as you said, I can read your question, that there are a lot of contradictory extraterritorial laws. And just because of contradictory laws between nations, there can be a lot of challenges. That is where there has to be a global practice or global recommendation coming in. So GDPR, when Britain or when UK was part of the European Union, was more like the entire Europe and UK would follow that. But with Brexit, I guess UK and Europe is again in talks about policy and rules when it comes to data exchanges. So it's very important for global or at least regional regional platforms or regional panels or regional forums to come out with universal laws and regulation which is applicable to all the trade which happens in that region, or maybe to be very optimistic, to all the trade which happens across the globe.
Yeah, because I mean, you see things like where U.S. companies have to, or even let's say a Malaysian company doing business in the U.S. has to comply with GDPR, even though they have no real links with Europe because there may be some European customers, and they also need a separate compliance regime for CCPA, which is the California Privacy Act. And as you know, the Europeans have indicated that their enforcement regime is to try to get you to comply, whereas the California Attorney General has said that his enforcement regime is punitive.
Absolutely, I understand that.
Very interesting question.
Gentlemen, in the interest of time, I see we've arrived at our 1 o'clock end time, and I'm going to bring this program to an official close. I will invite anyone who is interested in chatting further with Shrey or anyone else on the line. Feel free to stick around. I will stick around, and I'm happy to hear your comments about the program or future programs. If you have questions for Shrey, please stick around. And Shrey, thank you so much for your time and your insight into this important and current, very modern issue, and evolving issue.
Thank you so much for having me here.
It's our pleasure. So with that, we are adjourned. As stated, I will stick around, and feel free to stay on or leave as you wish. Shrey, there was one other thing in the chat there that I thought was interesting. Someone asked about safe harbors and whether or not safe harbors make sense in this set of regulations. So the safe harbor being one where, hey, if you are a certain thing or you do a certain thing, you're not liable. And are those kind of protections appropriate? And where do they exist? Should they exist?
So they don't exist as such, but then there are countries where you have laws which are very, very flexible and very, very lucid and very porous. So that is where people, for example, something like tax havens, right? Places where you are not taxed much, places where you can avoid taxes. So there are places where if you do any kind of illegal activities or something unwanted activities on data, you may go scot-free. But again, having said that, since it's an evolving world, evolving area, companies and countries are coming out with policies which are really very stringent. People are getting very, very cautious when they sign the terms and conditions. These days, they have started reading it to ensure that their data is not being misused.
Mm-hmm.